It's a real privilege to be here. Ron, thank you for those kind words. This is very important work we're about, and I commend all of you for being here today and those of you who are online to help us devise a better way to bridge the justice gap. As we know, COVID and the eviction crisis have exacerbated the access to justice problem in our country and brought it to the attention of many people. But still, there is that information gap. There's so many people who don't realize what a big issue this is, how important it is, and how we must work harder to solve it. As I said, some people have focused on it because of COVID and the eviction crisis, but it is, as you all know, a systemic problem. Ms. Rapp gave you the data points that most of us all know about. Measuring the size of this justice gap. I'm involved with another organization, the World Justice Project, that measures the strength or weakness of the rule of law in 140 countries. And tomorrow we will release the results of the 2020 Rule of Law Index. And sadly, the United States will be ranked 115th out of 140 countries around the world on accessibility and affordability of basic legal services. So it's not just a fairness issue and a moral issue. It's a rule of law issue. If you don't have access to justice, you can't say that you stand for the rule of law. So it's important that we delve into this. We work hard about it, work hard on it, and try to come up with innovative approaches to help bridge this justice gap. I think one reason I was invited to serve on this panel, as Ron mentioned, was my involvement in the ABA and the creation of a commission on the future of legal services. And that commission was created primarily to try to bring some great minds together and some hardworking people to come up with some ways that we could try to bridge the justice gap through innovation and technology. And through that effort, we work very closely with Legal Services Corporation. I see people around the room who contributed greatly to that effort. But we did run into opposition. There's a protectionist group of lawyers around the country. Interestingly, most of the opposition to these resolutions and efforts came from the New York State Bar, the New Jersey State Bar, and the Illinois State Bar. And they were entrenched in their opposition to these resolutions that promoted innovation in the delivery of legal services. And that still is a strain of opposition that you see in the American Bar Association House of Delegates. But there is hope. Some states are experimenting. They're doing a terrific job of coming up with innovative ways to provide legal services using technology and using those who are not licensed to practice law. There's some developing case law that gives more flexibility to persons who are not licensed to practice law to provide those legal services. So today, we will hopefully provide some optimism on how to help bridge this justice gap so that we can deploy greater person power to address the issue. So I'm honored this morning to serve on this panel with such a committed group of individuals who've proven they know how to innovate and how to make greater use of non-lawyers. With me today, Nancy Iverainen, Program Director, Paralegal Studies Program, Whatcom Community College, and former chair of the Washington State Limited License Legal Technician Program. And we'll be talking a lot about that today because at one time we all thought and hoped that was going to be the model for the rest of the country. Allison Paul, Executive Director, Montana Legal Services Association. The Honorable Kirsten Thompson, Senior Circuit Court Judge, Oregon Circuit Court, and Chair of the Paraprofessional Licensing Implementation Committee of the Oregon State Bar. And Hallie Bonger-White, Dean, National Tribal Trial College, and Executive Director, Southwest Center for Law and Policy. So we have a limited time, so we'll jump right into the questions and this learning opportunity. So Allison, let's start off with some context from Montana and nationwide. Why do we even need to look beyond lawyers to help close the justice gap?
Necessity would be my answer. In some parts of the country, you can't swing, as they would say in Montana, you can't swing a dead cat without hitting a lawyer. And in that would be DC, right? But in Montana, there's only for the whole state, there's 3,500 licensed lawyers. That when you do the math, when we do the math, if we look at it, there are 23 legal aid lawyers for the whole state, and we only have one program. So that's one legal aid lawyer for every 15,000 people living below the poverty line. There is zero way we're ever going to represent everybody. There's one lawyer for every 250 people above the poverty line. Our population density gives interesting statistics because there's only 6 people per square mile in Montana. And so it's a very stark idea of what rural looks like. And there just aren't enough lawyers. The majority of people in court in Montana are unrepresented in civil matters. It's just the way it is. And so we have to come up with other solutions to help people because, as we all know, it's a complicated system. And if you aren't given instructions, how do you know how to help yourself in court?
Thank you. Judge Thompson, I'm guessing from Allison's comments about the justice gap and lack of lawyers in rural America, it must mirror your experience in Oregon. So why is Oregon piloting the licensed paralegal professional program?
So in Oregon, we are in the process of starting the licensing of paralegals. And one of the issues is we haven't exactly decided what to call those licensed paralegals when the program is implemented in the end of June, 1st of July of next year. So we have the rules, we have the structure, but we're not 100% sure. We know that we don't want to call them triple LTs as Washington State did, just because of the confusion factor. The background in the program that I was fortunate to be involved in is Oregon does have a similar dynamic as Montana. We're not quite so large and not quite so spread out, but there's a huge difference between Eastern Oregon and Western Oregon, where the Willamette Valley has Portland and Salem and Eugene, and there are a fair number of legal professionals. But the vast swath of Oregon is very rural, and there are very few lawyers. Now, Oregon has a difficult time right now. We're having a really hard time having attorneys, for example, in public defense work. We have really just a dearth of attorneys in rural Oregon. So in Oregon, the Oregon State Bar had a futures task force that was appointed by the Board of Governors. They produced a report in 2017, really documenting the lack of access to justice throughout the state. And they recommended that there be licensure for paralegals in the areas of family law and landlord-tenant, two really high need and high volume areas. As a judge, those were dockets that I served on many times. And before I became a judge in my practice, it was family law and also landlord-tenant, going back to when I was a legal services attorney in Oregon City, Oregon in the 80s. So it's been a chronic issue, and I think the lack of attorneys has been exacerbated over the years. So I was asked to chair a committee. The Board of Governors decided to form an implementation committee in 2019. I was asked to chair that committee in 2020. I decided to accept the role, and then all of a sudden the pandemic hit. But a committee was formed. And I want to talk just a little bit about process, because I think the process was really critical to us being able to be successful in creating an implementation plan. We had a strong, focused committee, including attorneys who were specialists in the area of family law, landlord-tenant law. We had 2 highly experienced and committed paralegals, a representative from our Young Lawyers Division, a public member, and then we were staffed by just superb staff members from the Oregon State Bar. Then we had a ginormous advisory committee. I really mean that. We had, if people were interested, we said, hey, come to our meetings. And we met every 2 weeks by Zoom, beginning in about September 2020 through the spring of this year. And we continued to present our findings and our recommendations to the Oregon Supreme Court. I say this because there were similar kinds of comments in terms of this is not a great idea from folks within the Oregon State Bar, attorneys particularly. The experience of attorneys is often that is invisible to them, that there are many, many people who are not receiving legal services because the cases that they're involved in. So they don't see the many, many other folks who come to the courthouse on a daily basis with their landlord tenant and their family law cases, and they're never, ever able to speak to anybody, get any legal advice or guidance, other than perhaps a family court facilitation office, which is something we do in Oregon. And I think most states around the country do something similar where there's someone to help with forms, but they can't provide legal advice and direct assistance. So we've threw the net wide open to get all those comments along the way and to kind of keep the doors open. It ended up being a very fruitful experience in terms of being able to get our rules drafted and have the unanimous support of the Oregon Supreme Court to license paralegals, and it will be rolling out. But it was important to have the doors wide open, to gather the statistics and keep educating the public about this and educating the bar about this. Each state does what they do in terms of legal services provision in their own unique way, and they all believe they're correct. So they probably all are, but they're all doing it in their own unique way. We have the advantage in Oregon of having requirements of liability insurance for persons who are licensed to practice law. So we have a professional liability fund that attorneys are required to participate in unless they have other proof of coverage. We had excellent support from our professional liability fund as well to reassure that trained paralegals would be able to be insured. There would be consumer protection, and we are hoping that this is going to provide greater access to middle and lower income Oregonians who at this point are just priced out of the market, particularly in family law areas. So I could go on, but I don't want to dominate a whole lot of that. But it is just, in my view, the most important thing for those who are considering something like this. Throw the doors wide open, bring in the folks who are questioning what you are doing so that they can have their questions answered and turn into your advocates. We found that with many people who were involved in the process that we engaged in Oregon.
Judge, that's a terrific lesson on process. Can you give us, other than the risk management, can you give us just a little bit more on the core design principles of the program itself? So our core design principles were, and I think that you all may have on your programs, we created this little one-pager. It's, was designed to be a front and back that shows what the minimum training requirements are. Essentially, the pathways to licensure for a licensed paralegal include having a paralegal studies degree, so an associate's type program in paralegal studies, 1,500 hours of supervised practice, and then 20 hours of required basic education in terms of the concepts that they will be dealing with and understanding limitations of practice, which was a very, very big concern. And a realistic one for lawyers to say, so these folks are going to be licensed in limited areas. Are they going to know where the guardrails are? And that's an important part of the basic information. And then a requirement for continuing education and so forth. So that's kind of the basic pathway is that paralegal studies program, 1,500 hours of supervised service, 500 in family law, 250 in landlord tenant in order to be licensed in those areas. The other pathway in is going to be highly experienced paralegals. So my assumption is the first folks who are going to be licensed are probably those excellent paralegals that many of us have worked with as lawyers or as judges. We know these folks. They know how to do stuff. And they're already doing a lot of direct client service with some additional basic education. Again, the 20 hours of basic CLE, some competency and ethics testing, and the requirement
of a character and fitness background check. These folks will be able to get licensed, be able to obtain assurance, and then be able to provide direct service to clients, whether that is through an attorney's office or as an independent practitioner. Because like Montana, there are a lot of small towns where there's no legal office, there's no law office. You go to John Day or Burns, a couple of the cities that I have served as a senior judge, a vast swath of territory. They have one judge who has two courthouses about an hour and a half apart that he goes to and from. There aren't very many legal practitioners at all. So there may be the paralegal, the licensed paralegal who has his own office or her own office and does direct client contact without having an attorney that they're directly involved with. Or they might be through an attorney's office and be that satellite office.
Thank you. Nancy, you chaired Washington State's limited license legal technicians program. The result there was not quite as successful as what we just heard described in Oregon. What was the program about and what happened?
Well, the program itself was actually pretty successful. We do have 75 licensed triple LTs, and they are providing services, many of them in rural areas, and certainly to moderate means and the working poor. That was pretty much their target population. The program started with an edict from the Supreme Court back in 2001 to the Practice of Law Board to please find some way to use non-lawyers to facilitate access to justice. And so after many years of hearing from people, working through models, talking to people in the bar, talking to educators, the Practice of Law Board came up with this concept of a legal technician. And we didn't want to call it paralegal because paralegal is many, it can be many things. And so we tried to come up with a term that reflected that there was a limited license. And finally, in 2014, the Supreme Court approved the idea of the limited license legal technician to practice in family law. And that's because 85% of the family law cases in Washington are pro se. And it's really difficult to navigate your way through those cases. And when you look at the importance, it isn't just the need. When you look at the importance, what happens to children for their next 18 years is really critical. And so the limited license folks began in family law, and that required a paralegal degree. And we followed the core curriculum of the American Bar Association for their paralegal program approval. We also added in an experience component, initially 3,000. We got it dropped down to 1,500. In addition to having the paralegal degree, people needed to take 5 credit classes. It was a 3-quarter sequence in family law. They had to pass a background check. They had to take a test that our board developed with a testing company, and they had to have a bond requirement. So it was we thought, a very successful model, and we wanted to make sure that the consumers were protected. Because one of the first things we heard from lawyers was, oh, these people won't know what they're doing. And so we tried to make it academically rigorous and the knowledge base robust enough that these people could provide services to pro ses. And what they do is they will help people with forms. They will provide them with legal advice. If they need to craft a parenting plan, they will get legal advice about how to do that. If they need to divide property, they get legal advice about what perhaps that would look like, and also the way that one should go about that. And what happened was, even though we initially had support of the court and even our Board of Governors, there was a changeover on the Board of Governors. The family law lawyers in particular resented this program. And so with a push from them and the Board of Governors, the Supreme Court sunset the program. But we still have 75 people who have limited licenses, and they're going to remain. And we're hoping eventually that we can unsunset it and come up with something that everybody will live with.
What's the effect on service to the rural populations and the underserved with this program being sunsetted and only 75 out in the field?
Well, we worried about that, and we specifically worked with the community colleges, because the community colleges are in those rural areas and frequently include the populations that we want to cover. And so we're still hoping that we can continue that networking through the community college paralegal programs. And we're just trying to get our folks out there as much as possible to provide those services. And we are also looking at finding some other ways to deliver those services. For example, we have in Whatcom, at Whatcom Community College, a street law program that's done in conjunction with our local pro bono program. And so the paralegal students do the intake of the client, and then they go with the client to meet with the lawyer to hear what that legal advice is for that particular person. And the pro bono program provides the coverage for malpractice, and our paralegal students do a lot of the intake, which helps with the workload. And so we can get an awful lot of clients through a 2 to 4 hour clinic.
Well, maybe in due course, when the public and the bar sees how successful these triple LTs are and they're not a threat to the legal profession, maybe the circumstances will change and the program will be revived, because it certainly has great potential. Hallie, we know that the justice gap is just as dire, if not more so, in indigenous communities, whether individuals or people seeking justice in tribal courts or state courts. You run a free educational certificate program that trains non-lawyers to provide limited representation in tribal courts with a focus on providing services for victims of sexual assault and intimate partner violence. Who are the students pursuing certificates in tribal court legal advocacy?
Well, bonjour and good morning in Boker Tov. So I'm non-Indian, and I married into the Citizen Potawatomi Nation, and I have 5 CPN kids and 4 CPN grandkids. And I mention this because I'm non-Indian. I've been living and working in Indian country for many decades now. And we started out originally through a grant from the American Bar Association and the United States Department of Justice at the University of Arizona, trying to train law students through a law clinic how to represent victims in Indian country and tribal courts. And we did that for many years, and it was a struggle, and we kind of flipped it. So now what we're doing is we're training Native people who are lay people at a law school how to represent their own people in their own tribal courts. And we're having much greater success doing that. So we have, our ideal student is somebody who is from that community. So I would say, like, I'm also the admissions director. We're a small shop. So if I got an application from a Native woman who is a mom or a grandma, maybe she works as a victim advocate or in social services, but she has some indicia, something in her application that shows that she's a problem solver. She knows how to get things done. She knows her community. She's fully embedded in the community. She knows all of the resources that are there. That's the person that I'm going to be able to train in 6 months. My dad was a used car salesman, so I brought, some visuals with me. So that's who I can train to go in and provide the legal services that are missing in those tribal courts, because they're not leaving. They're not going anywhere. They're not just going to be there and, pay off their student loans or be a tourist having some time at Navajo Nation, right? These are people who are from there, and it's relationships. It's not transactional. It's relational. And so my students are from those communities. They stay in those communities. We give them the skill set to be able to do basic family law, protection orders, and victim rights representation. Now our funding is really limited. So in my fantasy, we can get more funding to do these other things. Like we're trying to develop a certificate for our legal, we call them legal advocates. That's the terminology that we use for our legal advocates to be able to do guardian conservator work. Or so we just kind of synthesize what are the greatest legal needs that we have in tribal courts and in Indian country, and then try to give certificates in those discrete skill sets. So right now we have about 230 graduates of the National Tribal Trial College who are licensed to practice law in tribal courts, and who provide oftentimes free legal services in those tribal courts. And the priority of service is to survivors of domestic and sexual violence, which unfortunately for our population is the vast majority of clients.
Do you have non-native participants in the program?
Yes, we do. So I'm non-Indian, but I like to think that I'm maybe bicultural after 43 years living and working in any country and being married in and sort of devoting my personal life and spiritual life and my professional life to working with Native people. So we do have non-natives, but we don't accept tourists. I just turned 60. And one of the things that I found in my life is that it's easier to teach people like how to change the oil in a car than it is to teach them about Native people's relationships to land, their history, their destiny, how to be a good relative. Like these are things that maybe take some people, because of who they are and their life experiences, are able to be embedded in tribal communities and have good relationships and understand that it's a different culture, it's a different way of being. I hate to be too groovy on this, but it's easier to train Native people than it is to train non-natives. So the non-natives that we have in the program are people who are either married into the tribe, or they've been working for the tribe. They're the social services director for 22 years, or they have some demonstrated relationship of cultural competency, because I only have them for 6 months. And in 6 months, it's hard for me to get the light bulb to go off into people's heads and to have them truly understand what the needs of the community are. And also to be a person that people can trust, because there's so much trauma in Indian country. And so to come in and look like me, there's just a way of being and a representation of self that will engender trust. So that's really hard to teach. So the non-natives that we have, and we do have maybe 15 to 20% of our students are non-natives, they have a demonstrated connection with the tribal community. So they have, a horse in the race, right? And they have some, their sense of self and personhood is also tied in with the work that they do.
Thank you. Allison, your organization, Montana Legal Services Association, recently started a tribal advocate incubator project to train lay advocates to represent people in tribal courts statewide. Why is a legal aid organization taking this on, and how did this project come about?
So we were fortunate to receive funding from the Legal Services Corporation under the Midwest Disaster Project, funding from the Margaret Cargill Philanthropies, which has been very, they came to us and they said, in a disaster situation, what do you need, right? And what we said was, we need people. We need trained advocates in tribal courts, because especially when COVID hit, and we have 7 reservations in Montana, and I'd say more than half of them closed their borders. And so then there's nobody to represent people in court. And tribal courts in many ways are more sophisticated than district courts, because they have their own bar association, or they have their own bar exam. And you don't have to be a lawyer in most tribal courts to take the bar. pass it and become licensed to practice there. But we just don't have, there's no in Montana organized program. We were lucky enough actually to get one of Hallie's graduates to run our tribal advocacy incubator program, which I didn't realize until I met her. And I'm like, oh, yeah. And she's a woman from the Crow Reservation, and she's put together this wonderful program that's all on Zoom, and then some in person. We have 10 participants, and it's more than a training program. It's also a business incubator. So we are working with them for a year. We give them the basics in kind of just down and dirty law. They have to know their own tribal code, right? And then we help them practice. So we can refer clients. We mentor them as the year goes by. And then we give them a little bit of incubator starting money to buy a computer and set up their office and go from there, right? So it's a lack of people. There just were not enough tribal advocates. Most of our reservations are quite far away from any city where the lawyers live, right? And so it's just a lack of services.
Thank you. Nancy, can you talk about the importance of having a diverse paraprofessional workforce that reflects the communities served?
Well, just as mentioned, for tribal purposes, having people who are from the same background improves the understanding of some of the barriers to the justice system. For example, out in the rural areas in Washington State, even on the west side of the mountains, which you've got Seattle and Tacoma and all of those up and down the I-5 corridor, but you go inland 50 miles, for example, one of the towns that I went to do pro bono outreach, the people did not want to do anything by internet. They didn't want to talk on the phone. They needed that one-on-one, sit down and talk to me and tell me what is going on and how we can fix this. And if we don't give them access to justice, they get alienated and they get angry. And I think that having people sit down and explain to them about the justice system and how this works and how we can get the justice system to work for them really helps. And it helps that they're talking to somebody that they know or that they know knows what their life is like.
Allison, going back to Montana Legal Services, you also have a longstanding AmeriCorps program that places non-lawyer navigators in state courts and other community locations. The program is profiled in a report from the Justice Lab at Georgetown Law Center, listed in the meeting booklet we have before us. What do the navigators do on a day-to-day basis, and how do they help rural clients?
So with our AmeriCorps program is really the backbone for our court self-help centers. We don't have the infrastructure for self-help in Montana. So I got together, the court administrator is a friend of mine. We sat down over a glass of wine and said, how are we going to fix this? And decided we were going to get an AmeriCorps program and train bright, young. Most of them are young. Most of them are just out of college and they want to go to law school and they want to see what the world's like. And so they come out, they help with forms. They provide instruction. We train them on not providing legal advice because half of them work with the court system. And we have partnerships with all kinds of agencies. So any place where you have intake and referral around legal issues. Our Office of Consumer Protection has 3 of them that answer the phone, and they all make referrals with each other. We have some that do intake and intake and referral, help with, like I said, help with forms, help with instructions. And then, Montana for Housing has one. Our court ombudsman for Child and Family Services has one. And they all can make referrals to each other and become a network at a different level than you would have, because they're the ones actually talking to people, right? Than you would have if it was just the professionals up here.
But if these members of the AmeriCorps are not from rural communities, what do you do to help them adapt and be more responsive to the people they're designed to serve?
A lot of information. One of the things that we do is with both our AmeriCorps and our staff is we take them on, you have to do a rural outreach trip if you work for us. And so you literally get in the car and drive through eastern Montana, which it's a whole lot of nothing, right? With tiny towns, and you can go for miles and miles and miles without seeing anybody. And if you haven't ever had that experience or even been in a small town, you don't have the same sense of what the challenges are like, right? So we make them visit and like, not be a tourist. I like that, Hallie. We have the same issue a lot of times, but, be a part of that community and see what people really experience.
And you only have them for maybe a year or two, so you have a lot of turnover. So this
We do. They're 11-month terms.
so how do you make the best use of them in that short period of time?
Training and technology. That's the answer. You do a lot of infrastructure building so they can, and they come out, I would say half of them, they all come in wanting to go to law school and only half of them actually go.
Judge Thompson, we know that many state courts are greatly under-resourced. How will Oregon's paraprofessional program be funded and sustained?
So the design of this program is that that the people who are applying to become the licensed paralegals or whatever we call them in the long run, they will be paying fees like lawyers do. In Oregon, a new lawyer pays a lesser fee than a more experienced lawyer. So the fees will graduate up from the first year on. And that's true also to some degree for the CLE, the continuing legal education. There are almost always reduced costs initially. Our anticipation is, and many firms actually, it's interesting. There's some family law practitioners who have been very protectionist. There are a lot of family law practitioners who have said, hey, as soon as this opens up, I'm going to get my paralegals licensed who are interested as quickly as possible, because it is rather obvious that this opens an area of serving clients who otherwise were priced out of hiring the attorney, but who will be able to hire the licensed paralegal for a more limited service. So there is not a funding source from the court. It's going to be fee for services. It is not going to address everybody's needs. And that is, we know that, but it is going to create a opening in the market for middle and lower income folks who are priced out to be able to hire the licensed paralegal to provide the services they need in their cases. And those folks are going to end up paying for their program to develop over time. One of the things that we were aware of in Washington State's experience, and since they're our next door neighbor, people are always asking, we called ourselves the PLIC committee, what's going to happen to these licensed paralegals, and are they going to be self-sustaining? I think unfortunately, Washington State's program was not very expensive in terms of the costs that the bar needed to pay. But even that very minimal amount, people pushed back on it. Our Oregon State Bar president and the Board of Governors have basically said, we don't expect this program to be self-sustaining in any particular moment. There's not that specific kind of a paradigm. It will grow over time, just as young attorneys grow over time in order to give back and pay their way. Young licensed paralegals will grow over time to give back and pay their way. And existing firms, as I said, many practitioners have already just said, hey, as soon as this is available, I'm going to make sure that I can license paralegals in my office. So that's kind of the court's not going to pay for it. The people are going to end up paying, really.
Thank you. Hallie, in addition to sending staff to your training program, how else can the legal aid community help bring more legal assistance to rural tribal communities?
I like the idea of, suit up and show up, like drive your car, know who your neighbors are, go there, introduce yourself to the clerk of the court and the judge and the prosecutor, like have a personal relationship. And this comes, it's bottom up and top down. So if you're a director of a legal services program, who's in your service area, what tribes are in your service area. Go out, bring a pan of Rice Krispie treats, or, stop by and get a couple dozen donuts on your way. Show up, press some flesh, say what you're going to do what you said you're going to do, and then consistently be there and not have it just be checking a box, because people can sense that. And send your staff, especially if you have Native staff, or if you know people in your community who might be interested, send them to our free, did I say it's free program, so that they can get licensed. And then also, when I say show up, like physically show up, and then also be supportive, right? So if you've got attorneys who are pushing back about legal advocates practicing and maybe taking away some of their business, use your voice, explain how it is that Native people don't have access to justice, and how we need to have these people serve rules so that children can remain in their families and people can remain in their homes. And then also, I would say, send people to programs, learn about your tribal courts, sit on committees. If you've got interjurisdictional, cross-jurisdictional things, build bridges, because it may take a couple years, 2 years, 5 years, 10 years. But if people consistently see your face and you're doing good work, which we all are, and we're there for people, then there's going to be increased access to justice. There's going to be improved relationships between tribal, state, and federal courts. Families are going to be healthier and communities are going to be safer.
All right, we want to leave a little time for Q&A. So this is directed to all of us. We'll start, Allison, with you. What's your 30-second elevator speech for why we need to look beyond lawyers to help us close the justice gap?
Mine's a 5-second. I'll say there should not be a monopoly on justice.
I like that. Judge?
So mine would just be respect the people who are already providing services. Think of the licensed paralegals or whatever they're called to come as the allied legal professionals who are providing direct services to people who need access to justice. They're like nurse practitioners.
Nancy?
The unauthorized practice of law is happening, and there are clients out there who are being victimized by people who represent themselves as independent paralegals or as being able to provide legal assistance. Frequently, these people are not just giving bad advice, they're charging more than lawyers charge for things like simple wills or filling out divorce paperwork. And if we don't get ahead of the wave by providing limited licensed professionals, we're going to get swamped by the wave. So we need to keep ahead of the wave and do this not just for access to justice, but also to keep ahead of the onslaught of the unauthorized practice of law. That's a lot of it is coming on the internet.
And we're seeing a lot of that in the immigration space, especially. Hallie?
I would say believe in the power of Native women to solve the problems within their own communities, hire them, empower them. And I'll just leave it at that.
Okay, good.
With this model, are there any limitations on the fee structure that the paraprofessionals can provide? And then what about limitations on incomes and assets, so that you really do make sure that you're assisting middle income and low income? I have some experience with this from the Milwaukee Justice Center, where we got pushback from the family bar that by helping people fill out forms, they weren't going to be hiring family lawyers. And of course, the statistics showed over time that that wasn't the case, and those attorneys then ended up being volunteers in the program. So I'm just wondering, what kinds of things have been done to sort of overcome those hurdles?
Okay. So the question about fee structure is, for reasons of antitrust, we can't do that in the Oregon State Bar. If the people are licensed, they get to set their fees. That said, in Oregon, the State Bar does very robust interviews and so forth to figure out what fees attorneys are charging and what they're charging for paralegals in their offices, because they're allowed to do that already for a paralegal working under the supervision of an attorney. And the stats come back that paralegals' time is usually charged at a fraction, 30 to 50% of what the attorney fee cost is. So we can't control it directly, but the evidence suggests that it's less. We have had some really fabulous triple LTs from Washington who have been super helpful in Oregon's process. Christy Carpenter, who is a triple LT from Washington, was one of our advisory group members. And in her practice, which she had from the inception of the program, she did charge a sliding scale and provided that information to us. And it was a fraction, 30 to 50% of the cost of an attorney in that area. And I think that as this rolls out, the bar is going to be trying to capture information from license holders on who their clients are. And again, informally, what we're hearing from triple LT practice is they are representing folks who would be priced out of attorneys.
Yeah, and in Montana, because our system, our tribal incubator, we also have a attorney incubator. It's because it's run by a legal aid organization. They have to, in order to participate, and we don't charge them, they have to agree to do so many hours of service to Modest Means, and they have to show a dedication to doing a Modest Means practice in a rural community. And so that is to get the benefit. And that's because we are going to make referrals, and we're referring low and moderate income people.
So one of the ways of regulating that somewhat, again, we can't set prices because it's anti-competitive, but we in our licensing regulations, we said that the legal technicians could not do quadros, a qualified domestic relations order. So no division of complicated retirement accounts. We also said that if the family home has more equity than the homestead exemption, that the legal technician could not do that kind of a division. And so you can carefully craft the ability of the limited licensed legal technician to do certain kinds of things, and that by its nature then will make them practice in the moderate means and working for and below.
And so you answered the first part around the fee structure. I'm wondering whether or not there's a expectation or requirement for pro bono work by paraprofessionals. Is that conversation happening?
Well, our Washington State Bar discussed that, and they do have an aspirational requirement, not mandatory, of 50 hours per year. Our legal technicians did way more than that just by nature of the populations that they're working with. And we were due to have the National Center for State Courts come in and do a study about the population that legal technicians were serving. And that was happening just as the program was sunset. So we're still looking at ways that we can collect data from our existing legal technicians to find out for sure what the population is that they're serving, so that we can show that it really is improving the access to justice.
So we've heard we've got a tremendous need for legal services for people in rural areas. And we've heard a wide variety of approaches, from experiential training for the AmeriCorps volunteers in Montana to actual, very structured programs, licenses. People would be able to put out a shingle and charge a fee. Do you have any advice about how to structure a program so that we can actually meet this tremendous need?
So is the question really how to take it to scale? Is that really another way of asking the question?
That's a good way to put it.
That's a hard question.
A hard question. I think you have to the reason our state you have to get people to work together. And Montana, I think similar to Alaska, is like a big small town, right? People know each other. They work together well. And you have to have everybody kind of rowing in the same lane. And that doesn't always happen with the challenges with the bar.
I do think it'll take time. And I think when people see the triple LTs are not a threat over time and the services they do provide, but it's a slog, I believe. I don't know of any magic bullet that will allow these programs, particularly because of the limitations of funds, but some others may have another idea.
Yeah, I don't think, again, I don't think it's a magic bullet, but I do think it is the sort of thing that if we begin to think of allied legal professionals extending service in the same way that we have, allied medical professionals extend medical services. Many professions have a gradation of professional licensure, and lawyers have tended to just be, we have lawyers, and then that's kind of it. And lawyers sort of can do anything with their license, at least in Oregon. If you have a law license, you can just put your shingle out and do whatever you think you can do. It's not very well regulated in that sense. And so helping the public to understand that these allied legal professionals will be able to provide the focused service at a more reasonable cost, I think is part of the answer. Not the whole answer, but I think it's, just helping the public to understand, oh, if I have this need, maybe I could see this kind of person. And because, again, in states like Montana, like Oregon, there really aren't that many attorneys. If you do a per capita count, there's just not enough of them to go around.
I think that's a great point. Just like in medicine, like you might want to go to a cardiothoracic surgeon or podiatrist or a phlebotomist, depending on what your needs are. And so I think that we don't make that transparent in the legal profession.
I think we're getting there. Obviously, we're getting there because we're here. But time in the law is like time in geology.
I had a logistical question and then an analysis question. The logistical question is, as I'm hearing you talk about the triple LTs and the licensed paralegals, are they meeting one-on-one? I heard that part with clients and then training them to be pro bono. I mean, not pro bono, pro se clients, or are they representing them in an adversarial process?
They are not representing them. We allow the triple LT to accompany their client to court, but the client is pro se when they go to court. So there's no speaking agent there by the triple LT. They can be there in court as a resource or go to settlement conferences or go to mediations, but they're there only as a resource for the pro se client.
Right. Is that true with all the programs?
Yeah.
No. Our so when you get a certificate in tribal court legal advocacy, and then there's an advanced certificate, and you're admitted to practice in tribal court, they're trained to do divorce, child custody, child support visitation, protection orders, and victim rights representation. But they have free agency if they want to investigate some other area of the law. They're able to go and do that in tribal courts. You don't have to be state barred or a graduate of a law school to practice in most tribal courts. So they have, the ability to practice poor people's law, or I guess they could do theoretically, personal injury if they wanted to with the certificate.
My second question is, you've had enough experience now to know, what do the judges think about this program? In other words, obviously all across the country, judges have been very concerned about the increase in pro se clients, and that's really clogged the courts, made life very difficult for the judicial process. So do they think this is working? I mean, from their perspective, are they like, yes, bring this into my court?
Yes, I do think that the family law judges really love this because it facilitates judicial efficiency. Even with the facilitator program, you have folks that may have limited literacy. And so being able to send these clients to a triple LT and then have the client go to court and be a participant in the legal system, it really helps speed things up.
Hi there. First of all, I want to applaud, Hallie, your work to develop local people and put them in place. And I wonder, Nancy and Judge Thompson, in your efforts, what was the success rate of bringing those graduates or those people who went through that program into rural places, or was it just low income? That's the first question. And to Judge Thompson, because there's a problem in market in rural places, which is why there's a justice gap in the first place. What's then the effort and energy? I don't see the word rural on this to ensure that works for rural and that it's closing the rural gap.
Just because of the number of people, a lot of the triple LTs were on the west side of the mountains and in the more urban areas, but we did have people in eastern Washington, and they would cobble together a triple LT practice with working with the local pro bono bar program as doing some administrative work there. Sometimes being hired by the local legal services provider to help out. So we did get some pretty amazing, and still are getting some pretty amazing work out in the rural areas from these very, very dedicated people. I couldn't tell you off the top of my head.
So in our implementation committee, we had Umpqua Community College from Southern Oregon and Portland Community College, from the Portland metro area, were on our advisory group. And then all the other community colleges around the state. Umpqua and PCC are the only two that have paralegal studies programs. But their sister community colleges, which are all throughout the state, we're very aware of, and the implementation committee's work. So part of that is the community colleges are sort of natural places for people who are living local, staying local, to get training and be able to embed into the community. We're hoping that that's one way that this will make its way into the hinterlands in Oregon. And there are lots of barriers, unfortunately, between, like Washington State, the west side of the state is where most of the people are. The infrastructure is there. The eastern side of the state, it's tougher. But we did what we could, and that's a continuing conversation for the bar and for the legal community.
One question has to do with the happy medium of training. Like, for example, in Oregon, you have this paraprofessional licensing implementation. And so my question is, does that in any way limit the number of paralegals that could provide services? Because like in Wisconsin, we often have paralegals who provide services. They're not really licensed, but they do know what they're doing. And so I was curious about that, whether there is a potential to require too much training that it actually might limit the paralegals who are providing services.
So one of the things that our implementation committee did actually was we looked at the training requirements of the Triple LT program in Washington, which are fabulous, but they're pretty rigorous.
Yeah.
And that was really our education subcommittee decided that was actually too hard a standard for too many people to meet. And there are something like 20 states around the country that are working on licensure of paralegals, particularly family law is a repetitive area. So we decided that looking at these different programs that we could adopt something that was somewhat more limited in terms of the training, because that was part of the feedback that we got. Part of the reason there are so few folks that were able to obtain licensure in Washington on a rapid fire basis was it was a high bar to meet.
Then my other question picks up on something that Hallie raised, which is, isn't there a way potentially to create a win-win situation for lawyers and law firms where they have lawyers, of course, but then also have paralegals who offer services at a lower rate, just as Hallie was suggesting for the medical profession. It seems to me like it's kind of like when you go to a large supermarket. You can buy the Cadillac product, you can buy the cheaper product, depending upon what you want. Isn't that potentially a win-win situation to encourage lawyers to use, to use paralegals?
Yeah, I sure think so. And one of our big allies as we were taking our program to the Oregon State Bar was a 45 or 50-year member of the Oregon State Bar who'd been a family law practitioner has offices throughout the state of Oregon and including in rural areas, was basically saying, I don't know what y'all other attorneys are worried about here. We want to get our paralegals licensed because it will extend our business model and allow us to serve more people. So, yeah.
So as we're talking about this in rural communities, I had a question about business. Are we teaching some of the paralegals that are going to be maybe potentially working in rural communities how to start a business, right? And how to get malpractice insurance? Because that's kind of the question that I have, in that they might not be able to find anybody to work with if there's no attorneys in those communities. So just curious about if that's something in the curriculums or things that you guys have thought about.
So I'll just say our program, yes, because it's an incubator. So we don't teach the business. We have, we've partnered with Native Development Corporations who come in and teach them how to have a business, right? And that's why we stay with them for a year. So we have mentoring, and so that there's some quality control and some help to get them up and running. But I don't know about.
Yeah. Part of our pre-licensure coursework requirements include how to establish a practice, how to run that. And part of the professional liability fund's mission to the Oregon State Bar is practice management tools, because malpractice, is often really the underlying source is just not knowing how to run your business well.
We have our core curriculum at the community colleges included some in there about office practice. And since the legal technicians are members of the bar, they have access to our law office practice management resources. And I think it was covered. And if it wasn't covered, the bar provided them with everything they needed.
We're sort of like battlefield medic training. So we're teaching people how to put tourniquets on and, doing chest compressions, the legal equivalent of that. So we do a little bit of it, but most of our legal practitioners are employed by, say, a domestic violence or sexual assault or services organization, or they're maybe attached to a prosecutor's office or a public defender's office. So they have some kind of structure. Maybe only 5% of our graduates go on to open up their own practices and have to do law management. So we could definitely suck up to Montana and figure out what y'all are doing there.
Could you guys speak to, a lot of the focus is on how it increases access to justice for clients, but I also think it creates a viable career path and opportunity for the folks who go into this. Could you speak a bit about, number one, that career path, and number two, then how it increases diversity sort of in the legal aid profession, which may attract more clients? Thank you.
I want to jump in and say that there's something about teaching people about their own laws and their own systems that empowers them so deeply. And one of the things that I'm most proud of is that a huge percentage of our certificate holders go on to elected office. They become tribal chairpersons. They sit on tribal councils. They just do really spectacular leadership roles. They become tribal court judges and tribal prosecutors. So there's something about training lay people who know that there's problems in their community. They don't know how to go about solving them. You give them the tools and the skill set to be able to solve them, and then the light bulb goes off in their mind. And then they have status in their communities, and then they become the people who people turn to when they have problems, about how to keep, safety and justice and health in their communities. So yes, I think that training this, a group of I hate to say paraprofessionals, but training this people, it opens up a career path, especially majority of our graduates are women and single mothers, right? So it gives them a good paying job. It helps them to give back to their community. It raises their status. So I think it's win-win-win all the way around.
And I think the placement of community colleges throughout the states is really important. And it is folks at the community colleges. They're usually members of the community, and they stay there. And so having programs at the community colleges, they're affordable, they're accessible, they're academically rigorous, and that provides good training and also some good consumer protection for those people.
So we were able to have community colleges do some survey of their current and former students about their interest in seeking licensure when the program rolls out. Very high interest. The Oregon State Bar also had a Lara Media, a research group that's an Oregon professional that surveyed a lot of clients, of prospective clients of these kind of professionals, and there was an interest in service from licensed paralegals, and also an interest in the profession in general. So that was something that we were conscious of. It provides a path to a meaningful career for folks who might not otherwise see themselves as licensed legal practitioners.
Yeah, ours is designed as a career path. So.
So Colorado is having the same question about a paraprofessional program, and we are getting that same pushback from the private bar. And I'm not sure if I'm inferring this incorrectly, but it seems like there was greater pushback with the programs launched as a statewide or metro-based program as opposed to the tribal courts. And maybe that's wrong. First of all, tell me if that's wrong. But also, I was wondering, do you think, in looking back, do you think there'd be something or an argument or less pushback from the private bar if you were to launch a paraprofessional program focused just on the rural communities?
Again, we would worry about the anti-competitive, antitrust trade regulation. And it was a limited license of the Supreme Court. And so it would be hard to do sort of those geographic restrictions.
Alaska, we had explored with the Alaska Supreme Court having the more rural, remote areas, being able to have our graduates practice just family law and protection orders in the areas where they're not perceived as competition for the local bar. But that was pre-pandemic, and we haven't followed up on that.
And I hate to say it, but some of our biggest pushback was from the rural areas in Oregon. So I don't think that was necessarily the friendliest audience to begin with. And dealing with the pushback was really answering people's questions over and over and over again, and helping them understand what we were actually trying to do.
Question for the panelists, particularly those involved in state courts, how you see the allied professionals work intersecting with efforts to simplify court processes and paperwork. She gives the example of it doesn't take a lawyer to get married, so why should it need one? Why should we need one to get a divorce?
So that's a really tricky one. I know in Oregon that some of the things that we've been doing in terms of trying to make forms available, make information available have helped. We also have what's called an informal domestic relations trial that is really ideal for self-represented litigants. It would be very ideal for folks who are assisted by paralegals to organize their materials and so forth. And and beyond that, I don't know I don't know how to answer that question, or if I've lost my train of thought at this point. So.
Well, Washington State has a patterns form commission, and our family law forms are all on mandatory forms. And so they're all available online on the court's website. And everything that you do in family law pretty much has a form that you need to fill out and boxes to check.
Thanks. Please join me in thanking our tremendous panel.